this means and ends issue is something which you will reflect on later. I'm not saying that I'm going to develop it right now. But what is this court doing? What this court is seeking to do
you already argued on
is to
that.
provide. No, I'm another aspect.
You have started on merits.
Yes, but I'm now deviating and I'm going back to a very important aspect which I want to emphasize because your lordships are saying that you'll reflect on it. What I would like your lordships to reflect on is it's essentially providing an intra-court appeal without an appeal. Without an appeal, it's going from 5 to 7, without there being an appeal, without there being a process, without there being a procedure. So it's something to reflect on. I'm not saying no. I'm sorry.
And if an appeal would arise, if we were to reverse the view insofar as your client is concerned, we are.
No, even on law, you see, I was just, anyway, I'll go on now to the stamp act, but I want your lordships to very seriously consider, because if you have in the future, some judgment comes which XYZ doesn't like, the question I ask myself is, can the Chief Justice of India constitute a larger bench and just put it before that bench without having a live list? Or decide whether there's a live list and then do it. I don't believe it can be done, but anyway, that's for your lordships to reflect on. Now, sorry. I'm sorry?
There is a second matter which is listed before my.
The Section 11.
Section 11 is listed before my lords, and that was placed before 5. Certainly, my lord, the Chief Justice of India in Dawoodi Bora can constitute a bench of the relevant strength. Seka Dobrik is listed before my lord. All this, my lord, may be there in the first matter. There is a second live matter which your lordships have listed.
There's no live matter, at least that I am aware of. There is some live matter there. Then that's the appropriate case. Then I completely agree with the amicus. In that case, an appropriate order can be passed.
I'm sorry, this is becoming a little excessive on this issue.
So it's a very serious issue, my lord. It's a very serious issue.
You are entitled to your view. I'm not saying this. It has been repeated.
No, because it's about the institution. And if this becomes a precedent, it's very, very.
On that. Said we may agree, may not agree with you, but
no, of course
that goes on.
Yes. So now let us go to the Indian Stamp Act, which is where I want to.
Nothing on both sides have argued. Absolutely. Let's not see what I'm personally finding in all these constitution bench matters. Things go here, there, everywhere. Everybody wants to have a chance. Everybody wants to say something instead of deciding what the issue is before us. That's the problem.
And now we are clear that there is a second matter.
The writer side, because chief is liberal enough to listen to all this, doesn't mean this goes on.
I'm so grateful. And we have a second matter. We have a second matter which is a Section 11 directly before us.
Because, my lord, we were the main.
Have you filed your written submissions? We look at the written submissions, no difficulty.
No, that's all that we are requesting for.
Highlight only one point.
No, please.
This is not permitted.
You know, this will not be permitted.
Will not be permitted.
I assure you that if you argue for another 5 minutes, you'll be washing out.
Within half a minute,
sir, listen to me, sir. You did that in the previous matter also in Sita Soren the other day.
Yeah, sir.
If you argue for another 5 minutes, you will be washing out the impact of the argument of the lawyers who have argued before you. So in your interest, please allow the other side to argue.
May I make a small request? Since I appeared before the Constitution Bench for NN Global, as also before the Lord 3 judges, was led by Mr. Grohman. Would your lordships care to hear me for 5 minutes?
No. We'll see how much time we have at the end, because we have to conclude by 4 o'clock today.
Nothing more than
that. Mr. Khambata appeared for SIAC, I'm appearing for the Hyderabad Center. Look, there are certain institutional points that we want to make.
No, in institutional points, I just wanted to clarify what you will address. Are you saying that the 11.6 must address the issue of limitation first? Is that the institution's view?
No. And the point I want to make.
That's the only issue we are deciding.
That's right. No, the only
what one institution may say, another institution may say is not relevant to mine.
The only point I want to make, in fact, Mr. Khambata sort of hinted on it. And my respectful submission is that your lordship should, in fact, looking at effectively parity, take the view that under Section 11, your lordships can't take evidence. If your lordships takes that view, then the entire Section 33 of the Stamp Act becomes inapplicable. And that's really what I want to make good. That's one point.
So you are really on this side, Mr. Diwan.
On the point of 11, in fact, that's what Mr. Khambata pointed out. But on the
your physical situation, situationing
separability.
He's undercover.
The reason why I am here is because on the doctrine of separability, My respectful submission is going to be that no, they're not separable documents for the purposes of the Stamp Act. And to that extent, the 5 judges are correct because you can't expand the doctrine of separability beyond section 16. And that's the other point which I've made. Good. I don't need more than 2 minutes. 10 minutes on these. That's it. Because Mr. Khambata has addressed your lordship suggesting what Mr. Khambata has suggested is that expand the doctrine of separability. My respectful submission is.
We are not going to that issue. I just
No,
don't
but that's the
understand.
basis. No, no,
We don't understand. It is narrowed down.
Correct. But why are you
After
treating?
narrowing of issues, still everybody wants to address on everything on this earth which is possible to be said under the earth.
There is the entire genesis of NN Global 1 was the doctrine of separability, suggesting that because of the doctrine of separability, the document didn't have to be stamped. And NN Global 2 goes and says, no, it is not separable. They are all part of the same agreement. The argument made by the other side is expand the doctrine of separability. That is going to be inconsistent with our act. It's going to be inconsistent with the entire line of English law decisions which we've continued to follow, which have clearly said that it is separable only for the perspective of invalidity, not from the perspective of every other matter. It is still a part of the bundle.
But it's not necessary for us to see what are the outer limits of the doctrine of separability here at all. We have to merely only decide as to whether at the stage of section 11(6)(a), the court is required to examine whether the instrument has been insufficiently
And
stamped.
on that point, my respectful submission is the way out of this conundrum is by taking the view that your lordships cannot receive evidence under section 11(6), because your lordships is not a court under 2(1)(e). If you're not a court under 2(1)(e), because the appointment goes either.
All right, yes, Mr. Diwan, let's hear.
That's one of the
Mr.
limits
Diwan,
of
yes.
submission that I will make.
So, Manoj, very quickly, may I just take you, please, directly to page 329 of volume 4A. So now I'm on the Stamp Act. So I'll just make a few comments and a few provisions. So first, your lordships may go to page 329 of volume 4A, where you will find the definition in 212 of executed and execution. Executed and execution used with reference to instruments mean signed and signature and includes attribution of electronic records within the meaning of section 11 of the Information Technology Act. Then just please read a little further, 214. Instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. B, a document, electronic or otherwise, created for a transaction in a stock exchange or depository by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. So, Manoj, I want to now just tie up these two definitions with the definition under Section 7 of the Arbitration Act. Arbitration Act is required to be in writing, where I think that's common ground. Please link that to the definition of the word instrument. I believe there is no escape from the fact that the arbitration agreement is an instrument broadly covered by this definition. Now, please move on. Section 3, your lordship knows, is the charging section, so I'm not taking you to that. Please go directly to Section 17. Section 17, which you will find at page 348, same volume, 348. Now, this is the point which we alluded to in the morning. Instruments executed in India. All instruments chargeable with duty and executed by any person in India shall be stamped before or at the time of execution. Now, this is the clear mandate of the law. So, I recall Mr. Datar was mentioning that he had his client in the old Madras City Civil Court days who used to only stamp 50% of the documents. All right, you run the risk, but the law mandates that you must execute at the time or before. Before or at the time of execution, you ought to pay the stamp duty. So this is something which the court will keep in mind. That's the time when you do it, but that's not all. So Section 18 is for instruments other than bills, notes executed out of India. So Manoj, with your permission, I'm going to skip that. Please now go to Section 31. This is important for my purposes. You will find it at page 355. Now, this is the route which we suggest to the court. This is the correct way out. What happens when a Section 11 application is filed and there is some dispute with regard to it? It's section, so I'm suggesting, I'll read Section 11(1) and then I'll just make this short submission. Adjudication as to proper stamp. When any instrument, whether executed or not, and whether previously stamped or not, is brought to a collector, and the person bringing it applies to have the option, to have the opinion of the officer as to the duty, if any, which may be chargeable, and pays a fee, such amount not exceeding ₹5 or not less than so and so, as the collector may in each case direct, the collector shall determine the duty, if any, with which the judgment, the instrument is chargeable, with which in his judgment the instrument is chargeable. So this is in short the route we are suggesting. First, on or before execution. If not on or before execution, shortly before you make a Section 11 application, just as you get your pleading drafted or before you issue a Section 11 notice. I'm sorry.
You are right. This is a provision.
Yeah, this is a provision and
1 minute,
this
please.
is the correct way. Yeah, I'm sorry.
Practical terms, if we apply it, it will be chaotic. It will be chaotic, to say the least.
No, why would it be chaotic?
Because
that's what the law requires.
because
I'm
you
sorry.
don't know what happens if you apply over there, how much time it takes.
No, so to that therefore I'm making another
And
suggestion.
the
I'm
type
sorry.
of orders which are passed.
No,
Again,
so I'm just making a suggestion to the
less
court.
said the better.
This is, no, possibly your lordship's experience
And
is
it's
wide.
not mandatory in law. It's not mandatory in
No,
law
I'm
that we
not.
have to go under 31.
No, so Manoj, may I just say this? As far as this.
Don't make it mandatory by a judgment of this court.
No, I'm saying that first, what is mandatory is at the time of execution or before execution. That's the mandate
the
of
stamp duty
one.
part. That's
Stamp
stamp
duty part. Second, it's not as if a party is hobbled and has to wait. He or she can, before issuing the notice under Section 11, arbitration notice, or before making an application, he can follow this route. I'm not putting it any higher than that. And your lordships, while molding the relief or issuing directions, may issue appropriate directions that in a case where the matter is pending adjudication, Section 11 can proceed. That's all. Now I go to the next point. Now look at 33. Look at 33. Please look at 33, which your lordship will find at 357. Now, examination and impounding of instruments. Every person having by law or consent of parties authority to receive evidence, and every person in charge of public office, except an officer of police before whom an instrument chargeable in his opinion with duty is produced or comes in the performance of his functions, shall, if it appears to him that such instrument is not duly stamped, impound the same. For that purpose, every person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it is stamped with a stamp of the value of the description required by the law in force in India when such instrument was executed or first executed. So here I make just 2 points. Your lordship said that we can look at marginal notes, at least to judge the drift, etc. of the section. This uses the expression examination, and then the second is impounding. I believe that I have no doubt, following your lordship's judgments, that when a Section 11 court is applying its mind, your lordships have held it's not mechanical. There is a application of judicial mind, and therefore the expression is examination, and this would cover a situation where a court is looking at it under Section 11. This is one aspect. Now, please go. Your lordships will just move on to Section 35. Section 35, which is on page 359. Now, please see this. Here we have there's a slight difference, at least on construction. We see this as 4 distinct points, but Mr. Khambata mentioned that there are 2 buckets. Please see, instrument not duly stamped, inadmissible in evidence, etc. No instrument chargeable with duty shall be admitted in evidence for any purpose by which a person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered, or authenticated by such person or by any public officer unless an instrument is duly stamped. So there are 4. 1, as your lordships correctly said, receiving evidence, admitting in evidence. That's 1. 2nd, acted upon. 3rd, registered. And 4th, authenticated. So there are 4 distinct situations which Section 35 envisages. Admitting in evidence is one of them. Section 11, I would respectfully submit, is not an admission of evidence stage. It's a stage of acting upon. I don't think there can be any, that's our submission. I don't believe there's any doubt, at least in our mind, with regard to the fact that the Section 11 court is required to act upon. Now, if this is the mandate of the law in terms of Section 35, I've already read the embargoes, etc., with regard to the section. Then the scheme of the statute, at least to us, appears to be that before a court under Section 11, if this issue is raised under Section 11, however narrow the jurisdiction, because undoubtedly it's a narrow jurisdiction, this would be within the duty and obligation of the court. Now, recent judgment is It's restricted to the eye of the needle. A fourth expression your lordships have used in Vidya Droli and other judgments is to cut the dead wood. The fifth is, it's a very narrow jurisdiction on existence and validity, which is the magic eye judgment. And of course, when in doubt, refer. So having regard to the conspectors of these tests, which are really different ways of saying that it's a narrow jurisdiction, nevertheless, according to us, just on a reading of the Stamp Act, and I have made my submissions on Section 5 of the Arbitration Act, there doesn't appear to be any reason or justification to exclude the operation of the Stamp Act at the Section 11 stage. Now, my lords, we are fortified in this, and here I'm just requesting you to please, I'll just request you to turn to, if you would, to Volume 2, page 6, please. So Volume 2 is my submissions. Volume 2, page 6. Please just go to page 6. It'll just save me a lot of time. Would your lordships have para 1.4? Sorry, Manoj, I'm on page 6. Do you have para 1.4 page? No, I just want to spend, I'll just address the court. Which page? Same thing? Para?
Line of what interplay the
To section 35 will apply because of the and shall or shall be acted upon.
Yes, acted upon. So there are two.
Acted upon is also qualified by.
Yes, yes. I'll
by
just
any
go there.
such person. Now, any such person means who?
No,
A
that's the
person
registry, correct?
having by law consent of parties authority to receive evidence.
Yes, but yes,
Acted
yes.
upon is also qualified by any such person. Any
Right.
such person means the person referred to earlier.
Right. No,
Now, there is a one public
can I-
officer. I mean, I don't know whether
No, but
can
we are a
put
court,
the court
Manoj.
is a public officer. Possibly the court is a public officer.
So, Manoj,
Sorry?
no, so this is, I mean, astonishing.
But a section 11 court may possibly be a public officer. Perhaps.
Here I may just draw attention to 33(2)(b). There's an act of delegation which the Stamp Act itself envisages. The court, High Court, can delegate this function of examining and impounding to an officer. which includes an arbitrator. He's authorized to take evidence.
Lords, in fact, my submissions deal with this very point, saying that all of this goes to the arbitrator if you read 33, 35, because what parties have done is that by consent, Lords, even in terms of the Arbitration Act, by consent, parties have agreed that as far as their disputes are concerned, it is the arbitrator who takes in evidence. That happens because of Section 19 of the Arbitration Act. So when you harmonize both the provisions.
The 33(2)(b recognizes this.
May I just make my, sorry. So I'll just, sorry, I'll just summarize it, how we understand it. We believe, if we are correct, that if it's going to an institution of any sort, this embargo under Section 35 won't apply under the scheme under which it presently applies. That's our understanding.
Yes.
That's one. Equally, we have no doubt that if it is the High Court or the Supreme Court, then it would be covered under Section 35, and it would be covered not in the sense of taking evidence, because your lordship may not be at that time admitting it to evidence, but certainly it is to be acted upon. That's why we sought to link acted upon with your other judicial responsibility, judicial application of mind to satisfy yourself on existence, however confined that jurisdiction may be. That's the short and submission. So we believe 35 does apply to a Section 11 court, and it does apply to the High Court or the Supreme Court, as the case may be. That's where we are, and the language is wide enough. Otherwise, it might be rendering this ocious. So that's it. So, Manoj, I was now on, if your lordship recalls, volume 2, page 6, please. Page 6. May I state the point?
Yes.
Yes. So we are on para 1.4. I'm drawing attention to 1.4 because of the constraint of time. What I want to just mention is that, look, we've had not just one stray judgment. In fact, to one judgment, Justice Gavai and Justice Suryakant are a party. That's the present judgment. We've had a series of judgments which we have encapsulated in paragraph 14. There's a total of about 12 of our judges who've looked at this over the years from 2011 onwards. And the narrowest SMS was, which is the 2011. That Justice, I think Ravindran and Justice Patak, they looked at it from the Stamp Act point of view. And they said that, look, this is clear to us, and therefore having regard to that, and they placed it on that. Thereafter, just have a look now, I'll read 1.4. It is submitted that this Honorable Court in SMST, so that's the first one. Then we've got Naina Thakkar versus Annapurna Builders. Well, that's also two learned judges. Black Pearl Hotels versus Planet M Retail Limited. That is three learned judges. Your lordship has that? 1.4. I'm on para 1.4.
Yes, got it.
Page 6, your lordships have it. So I'm just, to save time, just reading this. So we have SMST, that's the leading judgment, I mean, in point of time. Then we have Naina Thakkar versus Annapurna, which your lordship may note is two learned judges. Then we have Black Pearl Hotels versus Planet M Retail. That, I believe, is three learned judges. Then the judgment referred to Garware Wall, Justice Nariman and Justice Vineet Saran's judgment. Garware Wall is mentioned. And the present impugned judgment, which was also by three learned judges. So it's what the suggestion which we are making is that what has come about in the five-judge bench. I mean, I'm not saying that there was a reference to the five-judge bench judgment. There is a concern there. But when you have a long line of judgments spanning more than a decade in a situation such as this, on an issue such as this, I believe it is an eminently possible interpretation. The question before the court also is as to whether, because when there is in a commercial field a long-standing set of precedents and understanding of our court, we don't believe it ought to be lightly upset. Not that I'm suggesting that your lordship is not, going to consider this very fully, but I'm just suggesting to the court that please do not upset this, because we've given you a way out. The way out is not to give a premium on dishonesty of some person who decides for 50%, I am going to pay stamp duty for only half my cases and I'll take a chance. That's hardly the situation. The law requires you to pay stamp duty, pay it. If you don't pay it, the law gives you another chance before you approach Section 11. And if not, now I come to the if not, what is to happen? Now here, just please go to page 36, same written submissions, please. 36, please. Now here, now just have a look at two judgments referred to here, and Mr. Nair will expand on this. Your lordships have para 4.5. 4.5 your lordships have. So I'll just sum it up. So after our 5-judge bench judgment in NN Global, both the Delhi High Court as well as the Bombay High Court had occasion to examine how are we going to do this. So there are 2 judgments, Splendor land base, and there is a further one called, I think it's John Cockerill. Yes, that's mentioned in 4.6, correct? And they have given a streamlined process. So I am commending that with whatever further suggestions which your lordships may feel appropriate for the purposes of how to move forward sustaining NN Global. So this is another point which I thought we'll make. This wraps up the correct scheme. Now I want to make one further final set of submissions with regard to the Contract Act. Now I want to, may I just make that submission very quickly? Now please just take up the Contract Act. Yes, and your lordship will find that at page 280 of volume 4A. Volume 4A.
Provision are you referring to, Mr.?
Sorry?
Which provision are you referring to, Mr. Devan?
No, much was made of those definition clauses, etc. Now, I just want to point out what is the Contract Act saying, and the whole thing is void, etc. That's not the case at all. And since we're straying, I'm meeting this because much time was spent on these particular definitions and on how the Constitution bench has done it and how Justice Nariman in Garware dealt with it. So I want to just explain it. The standard, the original template which was used by our court was founded on SMS Steel, which your lordship sees Stamp Act. Thereafter, the bench felt in Garware that there may be another perspective. Now, what is that perspective? Let me just place it. So your lordship has now page 280, 280. So just now see the interpretation clause section 2, please, on that page. In this act, so first of all, it's in an interpretation clause. Then it says, in this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. Now, please go on to what was emphasized, G, 2G. Now, let's see what this, first let's read it, and then the context, and then see whether it has any reason to deviate from the 5-judge bench. G, an agreement non-enforceable by law is said to be void. Is said to be void. It's not it is void. It is said to be void for the purposes of this act. Now see the next one. An agreement enforceable by law is a contract. And then please see J. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So, the ambit of the expression in section 2 of the Contract Act is enforceability and relative to enforceability, whether an agreement is void or not. That is how this is to be understood. It's not to be understood, oh, the whole agreement is void, nothing can be done. That's absolutely a wrong way of looking at it. What the court is saying in Garware, etc., is that once you remove this taint, or you remove the shadow, as your lordship said, or the cloud, as your lordship said, then it becomes fully enforceable. So for all intents and purposes, your contract, upon being appropriately stamped, becomes enforceable. There is no peril to commerce, as is being suggested, that the whole entire, the country and commerce is going to come to a grinding halt if this judgment is allowed to sustain. A line of judgments which has held the field since 2011. So my respectful submission is, there is no justification on, and when your lordship recalls, for example, commonly, what do we understand? That if there is a fraud, for example, everything is void because fraud vitiates everything. But that's not how the Contract Act looks at it. The Contract Act says that if there is a fraud, it is voidable at the interest of the counterparty who was induced. So for the purposes of the Contract Act, what is void, what is voidable is much more nuanced than what is being suggested by the other side, and it ought to be understood in this restricted context. I'm very grateful. Thank you.
Thank you, Mr. Devan.